back, everybody. We're going to get started with our next session. It is my pleasure today to introduce Professor Bay, who will be talking to you about contract law fundamentals. Professor Bay comes to us from the University of Hawaii and is a professor of law at the William S. Richardson School of Law. She joined the law school in 1995 as acting associate dean and teaches contracts, legal writing, and advanced torts and insurance law. She's also the co-director for the Health Law Policy Center. Professor Bay also holds a PhD in American Studies and Masters of Social Work. She worked as a social worker with the elderly in the Hawaii community for 12 years. Professor Bay's awards include Outstanding Professor of the Year for 1999, the 2000 Board of Regents Excellence in Teaching Award, the University of Hawaii's highest honor for teachers, and the 2008 Hawaii Women Lawyers Outstanding Woman Lawyer of the Year Award. Please join me in welcoming Professor Bay.
Running over. Thank you for having me. I've been teaching contract law for 25 years to first-year law students, so I actually have to give a disclaimer that I'm really stuck in basic fundamental contract law, and you guys probably know tons more than me, so this'll I'm sure will be review for most of you. I wanted to start with the basics of contract law. The main source of contract law is the common law, and the common law is what we call judge-made law. It has a wonderful history going back to the Roman times and then all the way through England. And it's judge-made in that a case comes before the judges with facts, and the judge declares the law, and it evolves over time as new fact stories come to the court. But the legislature, that includes the federal government and the state government, are free to intervene and to take over any aspect of contract law that they want to. And I'll give you a couple situations where that's happened. The first is the Uniform Commercial Code, and that involves the sale of goods. There was a sense that goods travel from state to state, and there needed to be uniformity in the law. And so the Uniform Commercial Code was promulgated by private parties, and then they take it around to state legislatures across the United States, and 49 states adopted it. So when you sell goods in the stream of commerce, you can pretty much predict what the law will be across jurisdictions because there's a uniformity in the law. The one state holdout was, of course, Louisiana, which has a Napoleonic Code tradition, a French law tradition, and so they rejected the Uniform Commercial Code, Article 2. But for the most part, there's uniformity in the sale of goods. The other kind of statutory law that typically comes up is consumer protection laws. Those are usually at practices that are offensive, commercial entities taking advantage of consumers, and so either federal or state law will intervene and do something like the Door-to-Door Salesman Act, which gives people a right to rescind door-to-door sales for a period, for a couple days after the sale is made. Sometimes they're targeted at industries that are taking advantage. So for example, payday lending, rent-to-own, car sales, because there used to be sharp practices in bait and switch. So state legislators will target a particular industry because they need some regulation. And you can always preempt the common law by having a state legislature or federal government intervene and create a statutory scheme. The other big statutory schemes that you're familiar with are procurement laws, and that's where you need uniformity and you need an entire scheme. You don't really want ad hoc common law judging. You want to have regulations that are predictable and uniform and regulate the entire start to finish of government contracting, for example. And so when you have a need to have a whole uniform scheme, then it's not uncommon to have state legislatures or the federal government, the federal acquisitions law, for example, come in and make new law and then become less dependent on the common law. Beyond my class in first-year contracts, there's also international law that now regulates contract. We live in a global world, and so increasingly commerce is across jurisdictions, across nations. And so more and more international law and United Nations conventions govern contract law. In law school, students take those as advanced classes. I'm going to talk about some common themes in contract law, and I hope that as I go on with this talk, you'll begin to see how they permeate contract law, and they probably have some of those principles grounded in your procurement codes as well. The first is that contract law contains two different kinds of rules, what we call immutable rules and default rules. So there's a lot of rules in contract law. Offer an acceptance. For example, we have something called the mailbox rule that says that acceptance is effective when it's properly mailed rather than when it's received. They're what you call default rules. That means that the parties, when they make their contract, they can change those. They can make an offer, they can change the way that you have to accept an offer. They can change the terms of a contract in any way they want. So the default rules sit there and supply terms when the parties haven't thought about something, but the parties are free to change them. The other kind of rule, though, is immutable rules, and those are ones that can't be changed at all, and that's because they really affect public policy. And so those rules permeate contract law as fundamental core values. Some of those are the idea of efficient breach. First-year law students come to law school with a lot of high morality that has been instilled since they were children. And one of the most important things is that you should keep your word. Michelle Obama, in her speech at the Democratic Convention, said, "Your word is your bond." And so it's not too long after law school starts that my students realize that contract law doesn't believe that. Contract law is really amoral. And you're free to breach without judgment in contract law, so long as you can make the other person whole. And the idea of an efficient breach is that sometimes the world is better off if someone breaches a contract. Economically, everybody can be made better off, and I'll do this later with you when we talk about damages. So it takes very little time, frighteningly little time, for my students to think about contract promises, the law of contracts, is something that you can freely break so long as you can make the other person whole through a payment of damages. We also follow something called the objective theory of contracts. And the objective theory of contracts means that we don't really let people's secret intent govern what the contract is about, how the contract should be performed, whether the contract was formed or not. We usually judge people by a reasonable, prudent person standard. And so it's not the parties, there used to be this expression, meeting of the minds, but that's no longer the principle. It's really what would another person objectively think you meant by what you say or what you write in a contract. The final important fundamental core value of contract law is good faith and fair dealing. Sometimes we tend to say it as one word, good faith and fair dealing, but really what it means is that you operate with good faith, good intentions toward the other person. And a contract will be interpreted as if you wanted the other person to succeed, that you had a reasonable, fair interpretation of the contract, and that you're not there to outsmart or outwit the other party. And fair dealing means that you treat them throughout the life of the contract with fairness and honor your trade practices, your uniform, your trade usage, your customs and practices in your field, that's all incorporated in what the expectations of the parties would be. I confound students very early in contract law with this concept of consideration. If you think about it, you make tons of promises all through your life every day, but not all of them, thankfully, are legally enforceable, particularly the ones you make to your kids every day, for goodness sake. But contract law is a way to consider, the consideration doctrine is a way that we winnow or channel certain promises into the concept of contracts that are legally enforceable. And it's a very simple definition of what consideration is. It's a bargained for exchange. That idea, this idea of quid pro quo, actually encompasses two fundamental principles. One is that the one promise is sought for the other promise. So something is sought in return for the other promise, and that's a basis of promissory liability. And the other word in there is exchange, and what that triggers is the idea that something has to be legally sufficient. Whatever was exchanged has to be legally sufficient. A lot of things fall out of this concept of consideration when you think about bargain for exchange. The first is gift promises. If a promise is one-sided, you promise to give a gift, generally they're not contractual. I'm a fairly cynical and callous person, and so I often think that if, when you give or promise a gift, you're really hoping for something in return. But the truth is that you're really not bargaining for an exchange. You're not trying to bind the other person to that. And so gift promises fall out of this concept of consideration. Promises in recognition of past benefits also fall out because they're not bargained for. So if somebody has done something good for you last year, the idea that you would like to pay them back this year and make a promise to do so is not really legally binding because there's no bargained for exchange. The big one that comes up in commercial contracts is modifications of contracts. If you modify a contract by assuming that you'll take less for a project or you'll do more for a project, there really has to be consideration on the other side. They also have to give something. Otherwise, they're under a pre-existing duty. And the law generally says that modifications without consideration are not legally enforceable. That in particular raises issues that have not served contract law well. And I'm going to give you a couple hypotheticals. That's the way law students learn, is through these stories. So the first hypothetical is actually, these are actual cases. Neighboring merchants have 10 parking stalls, and one merchant generally promises that the other may use their parking stalls at night because they're closed in the daytime. Generally, that's a gift promise. There's no consideration if the other merchant's not paying for the parking stalls, and that wouldn't be really enforceable as a gift promise in the commercial context. Here's a second hypothetical. You're a landlord and you have a 2-year contract with a tenant. And this case actually happened in the Depression, and so times were really tough. You're supposed to get a rent increase in the second year. And the tenant comes and says, I really can't afford a rent increase in the second year. Would you consider keeping the rent at the same as the first year? And the court actually finds that the landlord did agree to this. But in the end, the landlord enforced the raise, the raise $25 a month. And the court said, that's right, because there was no consideration. The tenant was already under an obligation to pay the rent and gave up nothing in return. In essence, it was a gratuitous promise to accept a lesser rent. You can see that that would cause problems because you, of all people with procurement, know that during a contract you really want to be flexible. You want to be able to modify it as you want and have that kind of freedom. So the common law has evolved over the years, and this is an example of how judge-made law is so can be so effective. And so there's a wonderful case that I teach. I love it because I used to work for the city. So, you know, if you work for the city, the most important thing that a mayor can do is make sure the garbage is picked up, right? I mean, there's nothing more important in all the mayor's functions than the garbage. So this was a garbage man who had had 30 years of 5-year fixed fee contracts with the city of Newport, Rhode Island. And Newport, Rhode Island had grown very predictably by a couple houses every year. And so this fixed fee contract had gone on for every 5 years, for many, many years. And suddenly Newport has a huge population growth, and the fixed fee contract is in like the second year. And the city of Newport agrees to modify the contract and give the garbage collector more money because of the unexpected growth. Disgruntled taxpayers sue because, after all, it was a fixed fee contract. The garbage man had assumed the risk of how fast Newport would grow as part of the fixed fee. And so they challenged it as lacking consideration. And the court said, well, we're going to adopt a new rule in this case, a more progressive rule that's more rational, that says that you can modify a contract if you modify it in good faith, if you have unexpected changes or circumstances that justify the modification, and it's fair and reasonable. And so this is an example of the common law evolving over time to adapt to different sensibilities in different eras. And that's one of the flexibilities of the common law, is its nimbleness to adapt to new situations. Statutes are kind of fixed. And so I'm a fan of the common law as having the judge-made law having the potential to adapt and respond to people's needs at a given time. One of the biggest things the common law did was in the 1900s, the early 1900s. They recognized a completely new doctrine called promissory estoppel. And so it captured promises that were not supported by consideration, but nonetheless had caused someone to change their position. And so promissory estoppel says that if you make a promise, even if it's a gift promise that's generally not enforceable, and someone reasonably and foreseeably relies on it to their detriment, then that promise then becomes enforceable even without consideration. This is an example of courts making a whole new doctrine, and gradually courts across the United States climb on board with it, and common law evolves in this way. Hawaii's case is really a wonderful case. It's the story of a Honolulu Police Department officer, Sergeant Ravello, and he decides he wants to move to the Big Island to be a police officer. So a wonderful Honolulu police officer, he interviews for the job on the Big Island, and he's offered a job, but it's probationary, which means that he can be hired or fired at will for 90 days. And so they could always fire him for those first 90 days. So he prepares to move to the Big Island. The first thing he does is give notice to the Honolulu Police Department, pulls his kids out of private school, his wife quits his job, they get ready to pack up and move to Hawaii, to the Big Island, and the Big Island reneges on the promise. Well, remember, he was going to be an at-will employee, and so there's really not much that can be done with contract law to save him, except that the court recognizes this idea of promissory estoppel. And they say that, you know, when you promised him a job on the Big Island, even if it was just a probationary job that could be taken away from him at any time for the first 90 days, he relied on it to his detriment by quitting his job and getting ready to move. So the court recognized a cause of action in that case, even though under the pure consideration doctrine, he really wouldn't have been able to recover anything. He doesn't get the job on the Big Island, and he doesn't get his salary going forward, but chances are he gets some of the moving expenses or the lost wages he suffered. So it's a lesser kind of protection, but a protection nonetheless. going to talk a little bit about the objective theory of contracts. I don't know if you guys are Trekkies, but when you think of Star Trek, you think of Leonard Nimoy, Mr. Spock, and he can do this amazing thing called a Vulcan mind meld. I'm not sure quite what it is, but fortunately, contract law doesn't require that. We talk about formation of a contract, we talk about meeting of the minds, and that's that Vulcan mind meld. But the truth is that we don't require that. Contract law, contracts get formed very informally, they can get formed very casually, and we're judging whether they're formed casually, objectively, not by what the parties truly meant, but by what it looks like they meant. A good example of a very informal contract implied without any words is, let's say that I want to take my kid to a babysitter, and the babysitter says, well, I charge $10 an hour. And the next day I show up with my kid, they take the kid. There's an implicitly I've agreed to a $10 an hour contract, even though we haven't done anything formal. In fact, we haven't even said, I offer to watch your child for $10, and I say, well, I accept. Implicitly, just by the circumstances, the law will imply a contract. That can be quite dangerous for people who think that they want to get into a contract and they want all the bells and whistles and they want to know when they're bound and not bound. Generally, unless you're very specific and disclaim that you're in a contract, the law will imply a contract fairly easily and quickly. So parties are often surprised by that. Getting back to the objective theory of contracts, we judge people what a reasonable person in the other person's shoes would think or hear. So I have a wonderful case that my students learn of two old friends in a bar. He's always wanted to buy the other guy's farm, and the other guy has always said, no, I'm not going to sell it, I'm going to leave it to my kids. Well, they get into it's Christmas Eve, drinking, and the buyer challenges him, I'll bet you wouldn't take $50,000. And the other guy says, well, I'll bet you don't have $50,000. And they go back and forth for about half an hour. And ultimately, they create on the back of a receipt, they create a contract to sell the farm for $50,000. And the court enforces it, because while one party thought they were joking, the other party, according to the court at least, and the jury, believed that it was contractual. And so we judge people by this objective theory. Can be dangerous if you've got secret intentions. Your secret intentions won't matter. Contracts can generally, as I said, be informal. Another wonderful case I teach is some boss that's quite busy, and it's Christmas, and he's trying to do his inventory and all that, and his worker comes in and says, I want a raise, and the boss says, well, I just wanted him to get out of my office and go away. But his response is, you're okay, go back to work. And the court says, well, to the worker, that sounded like you were saying, okay, I agree to the raise. And so the contract with the raise is honored. And so it's the objective theory of contracts. You have to be careful. You have to be thinking, what's the other person thinking? It's sort of like dating and going steady. We like to give people mixed feelings sometimes. We're not quite ready to commit. And you have to watch it. You have to watch it, because it's really what the other party would think. Where there's a few kinds of contracts where a certain formality is required, there has to be written evidence with a signature of at least one party, the person that doesn't want to be in the contract, in certain kinds of contracts. We call this the statute of frauds. The typical statute of frauds covers land transactions, and those can be long-term leases and easements as well. We ask that there be written evidence signed by the party to be charged. In other words, the party that's trying to wiggle out of the contract, we have to find his signature somewhere on something that approximates the terms of the contract. It doesn't have to be the contract itself. It has to be some evidence of the contract in writing. Contracts that can't be performed within a year of their making. Contracts that are for over a year have to have satisfy the statute of frauds. And the sale of goods over $500 or more has to have evidence in writing. This is the statute of frauds. It's been around since 1677. Courts hate it. They've hated it since 1677. Legislatures enacted it. Our Hawaii legislature enacted it. And courts have had 400 years to try and create exceptions to it, and they've done remarkably well. So it's riddled with exceptions. There's actually judicial disdain because their thinking is, why should we let this technical requirement of a writing and a signature overcome obviously made contracts? And so they just have created tremendous exceptions to it. So I don't even want to say that it's particularly viable in Hawaii, because Hawaii in particular has had some real high anti-statute of frauds cases, even though it is on the books. I'm going to talk a little bit about contract interpretation. That's probably, it bedevils all of you in procurement law, right? You take the time to write a wonderful contract, and then what the heck does it mean in the middle? We generally judge things by the plain, ordinary meaning of the people. But the real danger in ambiguities is whether we're going to entertain extrinsic evidence or oral evidence to explain it. Courts are generally fairly generous about allowing a testimony to explain what terms are in a contract. And in Hawaii, that's particularly so. The other thing that comes along with every contract is trade usage and course of performance, the kinds of things that are customary in your field and how you've behaved toward one another in the contract. Those are all things that the court uses to explain what the terms are. So there's a lot of tools in the toolkit to explain what a reasonable person would think this contract meant in this particular regard. Even if the contract itself is unclear. Another important doctrine in contract law is the parole evidence rule. And that's a rule that says, well, if the parties bothered to write down something and they spent a lot of time and effort to make a writing, how much oral testimony should we allow into court to contradict or add to it? In other words, what is the value or sanctity of the written document? And there's a tremendous policy tension about whether we should honor the writing or whether we should allow people to come into court and challenge the writing of a contract and put on evidence that we really said or meant something different than was actually written on the contract page. And the parole evidence rule basically says that if the parties made a document and they agreed to it and they made it completely integrated, they tried to capture absolutely everything that they had agreed to, then generally we won't upset that by allowing testimony to come in to change or alter the terms. But we will allow testimony to explain terms. That's that ambiguity doctrine that we talked about. And we might allow additional terms to come in if it's something that hadn't been written about in the contract. The ambiguity doctrine and the parole evidence document, they really are at the heart of how important is the written document versus what the parties really meant. Ultimately, the goal of the court is to find out what they really meant in their contract. The problem is that the writing ought to be the best evidence of what they really meant. And so there's a tension, fundamental tension between letting in extrinsic evidence or letting the document stand for itself. Well, my students love the part of the class that talks about policing the bargain. And this is all the ways that people can outsmart other people. You know, there's people who are the con men in the world, and then there's the suckers. And I hate to say it, but I think I'm actually that gullible person that's going to be taken advantage of. So these cases are wonderful and funny and really quite cautionary. So these are the doctrines that help us police the bargain. The first is the capacity doctrines. One is that you have to have the age to enter into a contract, and in most states that's 18. So if you're a minor, you can usually avoid contracts that you've made, unless they're for something called necessaries, things that you need to live, or because a statute has enabled you or capacitated you, if you will. So for example, in Hawaii, minors can consent to mental health care. They can get jobs at 16. Certain things that they can do because the legislature has recognized that they should be able to do that. They're allowed to enter into contracts about reproductive health, mental health, those kinds of things. But other than that, they have to have capacity, which means they have to be 18. The other doctrine that protects people is mental capacity. You have to have mental capacity, but the law assumes that all adults do have mental capacity. So there's quite a burden on a mentally incapacitated person to actually establish that they were mentally incompetent to enter into a contract. The other doctrine is duress or business compulsion. That requires that somebody show that they had no realistic choice when they entered into a contract, and it was the result of somebody else overreaching. Requires both things. So usually in the commercial area, that's where another party drives a hard bargain, perhaps for a settlement of a claim, because they know that you're financially strapped and you have to take pennies on the dollar because you're desperate. Generally, we would call that duress if someone takes economic advantage of your dire straits in that way. The next doctrine is misrepresentation. And misrepresentation says that when you're entering into a contract, usually we regard contracts as arm's length negotiations. I remember my brother had a car and he was leaving the island. He asked me to sell it. And it was this car that in the morning when you started it, if you touched the brakes, you could literally fly through the windshield. I don't know what was wrong with the brakes, but they just grabbed. But within a quarter mile, they would warm up and then it would be fine the rest of the day. And so inevitably, people would come to test drive the car in the afternoon and the car would run really wonderfully. And I remember wondering, should I tell these people, in the morning? And I realized that I did tell them, the brakes are really tight in the morning, but no, and I don't think anything could have ever captured how really bad they were. So, but generally, you don't have to tell everybody everything when you're negotiating, but you do have an obligation to tell the truth if people ask or if you state something, and that's misrepresentation. There's a few things you have a duty to speak about. Another thing that happens in the duty to speak area is that this is a good example of where the legislature can get involved. So now in private real estate deals, you have duties to disclose under real estate laws. And that's an example of how the legislature decided that contract law wasn't responsive enough. And so they create a statutory scheme where there's more duties to disclose in residential real estate. Unconscionability is a relatively new doctrine, started in the 1960s in contract law. And what that says is that sometimes a contract can be so onerous and unfair, and the bargaining power can be so lopsided that we're going to undo the contract, rescind the contract, or avoid the contract because it was made under such offensive or oppressive terms. That's unconscionability. Courts acknowledge it, but they're really reluctant because, we make bad bargains all the time, and it's not the court's job to undo just ordinary bad bargains. Another doctrine that protects you is undue influence. And, Hawaii has an abundance of these cases, probably because we have such close ohana, right? We have aunts and uncles and nieces and nephews and grandparents that are all taking advantage of each other, and they all seem to be reported in the cases. So I particularly think that Hawaii, it's interesting how many reported cases on undue influence we have. But generally, that's where somebody uses their power of trust or a confidential relationship to exact a bargain from people that's really unfair to that person. And then the last doctrine is illegality or void is against public policy. You know, the legislature declares a lot of things illegal, and you can't make a contract about them. So for example, if I made a contract to murder someone, I couldn't go to court and say, well, they breached the contract, they didn't murder the person. An illegal contract, you leave the parties where you find them, and they're without a legal remedy. Legislatures all the time do that. In Hawaii, it's illegal to gamble. Gambling contracts would therefore be illegal. But the legislature is really slow. They're not nimble. So we ask the courts to do a lot of work in this area. So fertility contracts regarding adoption, in vitro fertilization, all those kinds of things that are kind of cutting edge organ transplants. The legislature sometimes can't keep up with technology and all the ways that people might offend public policy. And so we ask the courts to respond to situations. Well, I always tell my students, you know, breaching contracts and stuff like that isn't any fun unless there's money at the end. And so I'm going to spend a little bit of time on damages. Take a quick look at the timing here. We're doing great. So generally in contract law, there's three kinds of money damages. The first is expectation, and that puts you ahead where you would have been if the contract had been performed properly. And in Hawaii, we allow those as long as they're provable with reasonable certainty. So if somebody breaches a contract that was for 10 years and you were going to operate some business for 10 years, you just have experts come into court and try to prove what the business loss would be over the 10-year contract, and then monetize it back down to, or capitalize it back down to present day value of the contract. So expectation damages is the norm in contract law. But we also allow reliance damages. We talked about that in Ravello. Reliance damages put you back. Sometimes you can't prove your damages with reasonable certainty. And so reliance damages are usually very provable because they look back at how you were injured. So they're often really easy to prove. They're usually not as lucrative, unfortunately. And the last kind of money damages would be restitutionary, and that just asks, well, what's the other guy got that it's unfair he has now in the performance of the contract? Does he have something that he hasn't, that I haven't been compensated for yet? And so it looks in the other guy's pocket and says he should have to give that back as a result of the breach of the contract. We have some limitations on damages. So that's a dog sitting at home eating bonbons. Contract law says that damages have to be foreseeable at the time the contract was made. So you can't have, your damages have to be captured when you were negotiating. As a result, a lot of damages that flow from a contract that were unexpected are often not compensable. I already said we have to prove them with reasonable certainty. And we have to avoid damages if we can. We have an obligation to mitigate our damages. We can't recover if we don't take steps to avoid or mitigate our damages. Hence the dog sitting there eating bonbons. If you're fired from your job, for example, you have to make reasonable steps to go find another job. You can't just look at it as, I'm going to win this case and so I can sit home for the next year. The law prefers money damages over specific performance. We don't order people back to work as a general rule. And when we talked about efficient breach, contract law is not punitive. There are no punitive damages in contract law. You'd much rather, if you're suing, if you're in litigation, you'd much rather find a tort somewhere because the damages are a lot more lucrative if you're the plaintiff. No punitive damages. No emotional distress damages. And the case in Hawaii, I have a couple more minutes. The case in Hawaii is Russ Francis. Does anyone remember Russ Francis? So he was hired by KGMB and then abruptly fired. And of course he was a sports figure, and It's embarrassing to lose your job. It's embarrassing to be fired. And it's embarrassing when you're particularly a public figure like that. One day you're on the news and the next there's all this gossip that you've lost your job. So one of the things he sued for was emotional distress. And the Hawaii Supreme Court said basically it's a job, get over it. There's no emotional distress related to contract law unless it's of a particular nature where emotional damages are at stake. And those are typically the mishandling of dead bodies. I can't write this stuff. I can't tell you how many times funeral homes lose the body or bury the wrong guy. And so those are the kinds of contracts, really limited classifications of contracts where you're able to recover emotional distress. I often will ask a question for my law students about, well, what if the photographer forgets to put film in your wedding pictures or something like that? I suppose that would be of the kind where you might be able to get emotional distress. But as a general rule, there's no emotional distress damages. Contract law is not punitive. That means your liquidated damage clauses, I'm sure that there are liquidated damage clauses in a lot of your contracts. They have to approximate actual damages. They can't be penalty clauses. They can't be incentives or motivations to make people perform. Other countries allow penalty clauses or high liquidated damages, but in the United States we don't. I want to spend a second on efficient breach, and that is that let's say that you're an exterminator and you've got a job on one day to exterminate at somebody's house, put a tent over it, and then suddenly it has to be done that very day. A big old school system says, we want you to put tents over ours. You can't do both of them. And so you go to the small homeowner and you say, well, you know, I've got this other job and I want to do that instead because I'm going to make a lot more money on it. The law allows you to do that, and you're going to breach that contract with that small homeowner. The only thing you're going to have to do is pay for damages. So if you quoted the guy that you do the job for $10,000, and the only other person you can find to do it is $11,000, you have to pay him $1,000. But the world is going to be better off because some other exterminator got a job, and he's going to get paid $11,000. The homeowner's happy because he's going to have his house exterminated for $10,000, the price that you originally quoted. And you're going to be really happy because now you've got a big old school system job. And so the world economically is better for all of that breaching. And so that's why contract law is not punitive. So that's it. And I think I finished right on time, right? Thank you.
Oh, thank you so much, Professor Bay. We just love it when Professor Bay comes to talk with us because the stories are just fascinating. So appreciate that so much. And we have that video, so we can always look back on that. We will be breaking our meeting back up at noon, just in a few minutes, for our special luncheon. Please could you clear your papers from the table, place them under your chair so the luncheon servers can get the tables ready for lunch. Also, please remember to place your luncheon card that shows your food choice onto the table in front of you so the servers know which food choice to serve you. It's found at the back of your name tag. Mahalo, see you at noon. Thank you so much.
Together we can make some memories.